The Constitution was, at the time the vote was taken.
Yes.
I extend time by another 2 minutes.
Thank you.
I'm doing it for myself.
Very well, Your Excellency. Very well.
But at the time the referendum vote was taken, there was a valid, a lawful constitution in place.
Yes.
In a properly constituted state.
Yes, Your Excellency.
Which would presume the existence of an independent judiciary.
Certainly.
Why then didn't your state arm challenge the validity of the referendum in the usual way before the ordinary courts, instead of suspending the Constitution?
Your Excellency, thank you very much for pointing that out. Inasmuch as we would like to address that issue, Your Excellency, that is an internal matter with which the International Court of Justice does not have jurisdiction, Your Excellency. That is an internal matter which must be decided by the National Court.
We may not have juristic authority over that question.
Yes, Your Excellency.
But do you not agree that by customary international law, by the common law of international of this court, we are entitled to take into account the conduct of a state?
Yes, Your
in
Excellency.
relation to the dispute it brings before us?
Yes, Your Excellency. However, it is also...
If you are tainted, we are entitled to refuse you relief on that ground.
Yes, Your Excellency. However, Your Excellency, it is also a general principle of international law that political acts of a state that are within the exclusive domestic jurisdiction of that state, Your Excellencies, cannot be reviewed by international tribunals.
So in other words, you can murder your citizens and your neighbors must stand by and do nothing when they flee into their jurisdiction?
Definitely not, Your Excellencies. Your Excellencies...
But that's what you're saying.
No, Your Excellency.
Then it must be yes to my answer, my first question.
We beg to disagree, Your Excellency. We are making fine distinctions here, Your Excellencies, in that, with respect to...
No, we are not making fine distinctions. You are making fine distinctions.
By we, Your Excellency, I'm referring to us. I beg to apologize, Your Excellency.
All right. What are the fine distinctions you're making?
The fine distinctions here, Your Excellency, is that with respect to the political suspension of our Constitution, that is within the internal, domestic, exclusive domain of the national courts, Your Excellencies. But with respect to the violation of...
We extend time by 2 minutes.
Your Excellencies, the question of genocide or war crimes or gross violations of human rights, Your Excellencies, are a different matter because they are expressly...
But people were being killed. That's why the Argentines, 1/20th of their population was wiped out, according to the independent study.
Yes, Your Excellency, but in that respect, Your Excellency, may we refer the attention of this court to the compromise, where it's also stated that the Agathans massacred many Agathan people as well, which only points out to the fact, Your Excellencies, that this is not a one-sided civil war, Your Excellencies. It is a full-blown civil war, and under international law, Your Excellencies, particularly the additional Protocol 2 to the Geneva Conventions, Your Excellency, under international humanitarian law, if it is a non-international armed conflict, Your Excellencies, it is not international, and the international, if it's non-international armed conflict, Your Excellencies, other states may not intervene because it is purely within the domestic domain of the state involved. Your Excellencies, if there are any more need of my assistance, if any further question?
Thank you very much.
Thank you very much for your time, judges. May it please the Honorable Court.
The next speaker will wait until we call him. Yes. Yes, 20 minutes. 20 minutes.
Good morning, Your Excellencies. My name is Ernest, agent for the respondents. I appear together with my co-agents, Ms. Diana Law. I shall be addressing this court on the first two issues in relation to self-defense and self-determination. My co-agents shall address your court on all the remaining issues. Before going into the substantive submissions, there are two preliminary issues to be dealt with, as raised by the applicant. Of course, the first paramount preliminary issue is the application of the monetary gold principle. The rule says that the court should decline to...
Who is going to deal with the issue of the nationalization?
I will be dealing with the local remedies rule, and Mr. Law will deal with the substantive submission of the nationalization.
So I've got questions to ask about locus standi. Whom do I ask?
I will be your Excellency's assistant in that regard.
Can I ask you that straight away then?
Of course, Your Excellencies.
Because that's one of the preliminary points that troubling me.
Much obliged.
Do you have locus standi to advance the cause of the telephone company?
Absolutely, Your Excellencies. The first reason is being that the Sicilio Telecom Company is the fraudulent company, that is the second respondent's company, that is the national of the second company, of the second respondent, and the standing is given by the rule of diplomatic protection. In the present case, however, the respondent submits the contrary to what the applicants have said regarding local remedies. In two decisions rendered by the Permanent Court of International Justice, it was authoritatively held that where declaratory judgment is being sought, the local remedies rules does not apply. The local remedies rules applies before Your Excellencies only when other remedies, for example, monetary awards and other remedies are being sought. In relation to the last declaration on nationalization, only declaratory judgment is being sought, and therefore the rules on local remedies have no place before Your Excellency, and that summarily disposes of the applicant's arguments. Going back to the very first submission on preliminary issue, the monetary gold principle, this court, Your Excellency may well be familiar with the principle that this court will decline jurisdiction where the legal interest of a third entity forms the very subject matter of the present dispute. In the present case, the applicant has repeatedly referred to the state or province of Agifa, the intervention of internal affairs, basing on the assumption that Agifa is not a state, a proposition which is disputable, very disputable. It is a submission of the respondent that the applicant is trying.
But it is their business. They consider it as a rogue province, just as China considers Taiwan as a rogue province. So what difference does it make? It's none of your business. Why did you send your troops in?
Your Excellencies, the submission of the respondent would be that the claim of the respondent would essentially be collective self-defense and assistance to self-determination. And
But they prosecuted the man who bombed your country. They punished him.
Absolutely, Your Excellency.
By doing that, do you agree with me? By mounting by instituting the prosecution against Colonel Patton, they dissociated themselves from his act, and they are therefore completely absolved from the bombing.
Your Excellencies, in fact, the incursions into the refugee camps and the airstrike launched by the colonel is not part of the respondent's case. The respondent's case is collective self-defense. The right to self-defense is possessed by the state of Agifa. It is in the submission of the respondent that Agifa constituted a state, and now the respondent will...
But it is seriously in dispute that Agifa had actually properly seceded from the Republic of Donavaul, from the state of Donavaul. It is seriously in dispute by the other side. They say that the referendum was not lawful because it had been fraud. There had been allegations of fraud in the polls. Am I correct?
Your Excellencies, there has been certain allegation in that regard.
Am I correct?
Yes, Your Excellency.